Mr. Hedgehog, isn't it true that the defendant, Peanut, told you on Saturday that he was going to bite Dr. Robotnik?
Objection, hearsay.
Your Honor, while this is a statement made by a declarant, the defendant, out of court, and it is offered for the truth of the matter asserted, it is not hearsay because of exceptions under Rule 801 D2 and 804 B3. 801 D2 is a statement made by an opposing party, which in this case would be the defendant himself. Also, under Rule 804 B3, this is a statement against interest, as the defendant clearly admitted what he's on trial for.
Overruled.
Mr. Miller, isn't it true that on direct examination, you said that you had never even seen the defendant before, correct?
Yes.
So you don't know who the defendant is?
No.
Your Honor, may I approach the witness?
Yes.
Now, Mr. Miller, on this picture, is that you? And is that a dog next to you? And what does it say that dog's name is?
Peanut.
Now, is that a fair and accurate depiction of the defendant, Peanut, on trial here today?
Yes.
And that's you with him?
Yes.
So, in fact, you did know the defendant before this day. You have seen him, correct?
Yes.
Objection, Your Honor. He's using extrinsic evidence on a collateral matter.
Your Honor, extrinsic evidence is allowed on collateral matters when it's offered to show bias. And clearly this is an example of bias. The witness knows the defendant. In fact, he actually owns the defendant. While this also shows a prior inconsistent statement, if I'm offering to impeach the witness for bias, then extrinsic evidence is allowed.
Overruled.